All right, are we in a position we can start now?
I think we should maybe wait a few more seconds as people are signing in.
All right, let's give it 2 minutes.
All right, we're holding steady. I think we can start.
We're going to start the seminar now. My name is Stephen Cragg. I am chair of the Bar Human Rights Committee of England and Wales, and I'm co-chairing this session today with Scott Carlson, who's the Associate Executive Director for Global Programs at the American Bar Association. I'm delighted to welcome you to today's virtual event for the newly published report and recommendations of BHRC and the American Bar Association Rule of Law Initiative. The report is called The Edge of Law, a regional approach to confronting key legal challenges, and it's a culmination of a major advocacy project funded by the Foreign Office in the UK, a path-breaking series of virtual dialogues hosted by BHRC and ABA ROLI between November 2021 and March 22. And it addresses specific dimensions of forced labour, modern slavery, sanctions, data security and digital privacy, and judicial independence in Asia. Our discussion throughout the series were designed to reflect on the overarching question: what is the role of the legal profession in protecting human rights and the rule of law? Each of the virtual dialogues were designed to conclude with solid, actionable steps that participants and other stakeholders can import into regional law practice and policy making. For each event, we invited speakers from and based in Asia, Australia, the UK, Canada, and the US, and we welcomed exceptionally strong participation from the Asia Pacific region, including from Bangladesh, Cambodia, China, Hong Kong, India, Indonesia, Japan, Malaysia, Myanmar, Nepal, Pakistan, Singapore, Sri Lanka, South Korea, Thailand, and Vietnam, as well as from the wider international community. It's a very wide range of people has taken place in these events. Through these events, BHRC and ABA ROLI successfully created a regional platform where practitioners, academics, civil society actors and policymakers could openly discuss some of the most acute challenges to the rule of law in Asia, contributing to and building regional consensus on human rights realities in Hong Kong, China, India, and other Central and Southeast Asian countries. These are all countries where BHRC has heavily focused its global advocacy in recent years. BHRC's work in East and Central Asia in recent years, for example, has focused on allegations of atrocity crimes in Xinjiang and on the swift and severe clampdown on political and democratic freedoms in Hong Kong, as well as on Chinese human rights lawyers who continue to face a bleak crackdown. Many of the areas acute human rights crises and substantial rule of law concerns have been exacerbated by the pandemic, with increasing incidences of arbitrary detention of political prisoners without due process, serious and chilling interference with civil society, attacks on the right to peaceful assembly, the freedom of expression and information, and the insidious rise of digital authoritarianism. BHRC, as the independent international human rights arm of the Bar of England and Wales, has worked for over 3 decades to protect the rights of advocates, judges, and human rights defenders around the world. BHRC is concerned with defending the rule of law and internationally recognized legal standards relating to human rights and the right to a fair trial. Our vision is for a world in which human rights are universally protected through government and state actors' adherence to international law, obligation, and internationally agreed norms. Our mission is to protect and promote international human rights through the rule of law by using international human rights law expertise and some of the UK's most experienced human rights barristers. As we formally launch the Edge of Law report and recommendations today, we hope that you'll find this work to be a decisive blueprint for practitioner-led action and empowerment in Asia. For us, the Edge of Law is a milestone in BHRC's 30-year history and a testament to BHRC's commitment to using our significant legal expertise to build capacity for legal practitioners and human rights defenders on the ground and across the globe. I'm pleased to welcome some of our speakers from the series back today. And as I said, I'm co-chairing the event with Scott Carlson, the Associate Executive Director of Global Programs at ABA ROLI, and to formally launch our joint report and reiterate our commitment to seeing through the strong recommendations that are woven throughout this work. Our very special thanks to all our panel speakers throughout the 4 dialogues and the authors and contributors to the report, namely Diana Constantina, Pamela Katz, Dr. Louise Loder, Sarah McCoubrey, and Beenish Riaz, and of course, Dr. Felicity Gerry KC, Nighat Dad, and Professor Surya Deva, who are all with us today. Thank you all very much, and I'll hand over to Scott now.
Thank you, Stephen. And a big hello to everyone joining us today. I understand we have more than 100 people from all over the globe online with us today. And I want to start by thanking each of you for taking the time to join us. We understand, of course, that there's a lot of pressure on everyone's schedule today, and we really appreciate your interest in the issues that we're going to be covering today. Through the Edge of Law series, it has been our hope throughout that both the American Bar Association's Rule of Law Initiative and the Bar Human Rights Committee of England and Wales would be able to create a platform where we can exchange ideas on how best to respond to a lot of the new challenges that our communities and our legal institutions are currently facing. I think as the white paper report, which is being launched today, highlights, really the challenges we are all facing are immense. They cover every sector of society, whether it is the goods we purchase, how they are manufactured, to the information we share willingly or unwillingly, or the functioning of our legal systems and how we hold officials to account for violations of law. Really, each of these topics is expansive and more relevant today, I believe, than ever before. What is also clear from all the discussions that have been held in this series and summarized in the Edge of Law report is that collaboration across sectors and jurisdiction is really essential to responding effectively in today's modern world. I mean, we live in a global economy where our lives and legal systems are now deeply intertwined, really on a daily basis. And for these reasons, the American Bar Association Rule of Law Initiative welcomed the chance to cooperate with the Bar Human Rights Committee of England and Wales, an organization dedicated to the protection and promotion of international human rights through rule of law. And this is a vision that the ABA's Rule of Law Initiative shares. And in fact, it's been official ABA policy since 2008. You know, building on these networks that cross borders, finding common solutions and supporting action are really ABA ROLI's top priorities as a general theme. For more than 25 years, the American Bar Association has been working with its partners in more than 100 countries across the world to promote rule of law, access to justice, and really further respect for human rights. And through this work, we've had the opportunity to connect with bar associations, legal clinics, and lawyers acting as human rights defenders. And regardless of location, we support these individuals and organizations as they seek protection of democratic governments and the protection of human rights. think the Edge of Law series really represents a natural next step in our work in the Asia region, creating a regional platform where practitioners and academics, civil society actors, and policymakers can really openly discuss the challenges. And through the healthy exchange of ideas and experiences, we really seek to build, hopefully, some consensus, or at least a shared understanding of how we as defenders of human rights should respond to this really rapidly changing world. I think many of the recommendations in the report revolve around this idea of collaboration and noting the essential role that lawyers and bar associations play, particularly in new areas of law, such as data protection and digital privacy, or building a sanction regime that crosses multiple jurisdictions. Ideally, lawyers and civil society actors should be continuously engaged in the development of these regimes, from their creation to their implementation. Human rights is a central focus throughout. And in that vein, I think this report highlights the importance of lawyers collaborating with stakeholders in other sectors, whether it's learning from civil society actors and helping them carve out space to advocate freely against rights abuses, or working with corporate clients to make it easier for them to do the right thing when it comes to protecting human rights. Lawyers play a critical role in supporting clients tackling all of these issues. Another common, but perhaps more subtle thread running through this series and the report relates to the rise in autocratic tendencies and the need for lawyers to work with NGOs and allied governments really to build institutional resiliency and reinforcing ideas such as constitutionalism, separation of powers, as firm boundaries against authoritarian overreach. With the recent rise in authoritarianism around the world, we are all facing very serious challenges. And I think they're challenges that we really haven't witnessed for decades. Here at the Rule of Law Initiative and at BHRC, and many of you in the audience, we bring nuanced understandings of the critical importance of laws, functional regulatory systems, and the role they play in protecting human rights, combating climate change, or creating effective digital security. But as one of the authors noted, black letter law is no longer enough. We must acknowledge how these laws and our advice as lawyers fit within the larger global context, be it within a global supply chain, the environmental impact, or the use of data. And we must endeavor to minimize any unintended negative effects. Of course, this is not going to be easy. Alone, these challenges can be overwhelming. But we believe that these facts make it imperative that we cooperate, share ideas, and experience. As we do so, we should pay, I think, special attention to the unique experiences and circumstances of each jurisdiction. This is especially the case in a place like Asia, a vast area filled with different languages, ideologies, corporate ecosystems, religions, and cultures. As the report, I think, aptly summarized, nuanced cultural understanding is really critical, whether in the design of any sort of enforcement regimes that will align with international standards or when working with regional local experts to establish business practices. This need for a nuanced understanding against a set of common goals or shared goals requires opportunities and platforms like this for people to exchange their ideas and experience. And we really believe that this fact reinforces the importance of initiatives such as the Edge of Law series and this white paper. For these engagements really provide an open forum where these differences can be discussed and where the commonalities can serve as a foundation for us all to build upon. We really hope today's session can begin the next chapter in our collaboration, and we look forward to hearing your ideas as to how we can best continue to foster collaboration across our borders. In that vein, my colleagues are going to be posting a survey link in the chat to get your feedback on this series and how we can make it more relevant and accessible to you and the communities that you represent. Finally, I would be remiss if I did not acknowledge the hard work and time that went into this collaboration, not just for today's event, but for the 4 other sessions that took place over the last 6 months. And I'd like to thank all the speakers who participated in the panel discussions throughout the series. I think there were 12 experts from 9 different jurisdictions, and they provided the foundation of this report, our discussion today. And their bios are at the end of the report. I think Stephen mentioned the authors, and so I won't repeat them, but we're lucky to have these distinguished authors with us today. So what I'm going to begin now is introduce our first speaker. And our first speaker is Professor Surya Deva, and he's a professor at the Macquarie Law School. Professor Deva is an internationally recognized scholar in the field of business and human rights. He served as a member of the UN Working Group on Business and Human Rights from 2016 to 2022. Professor Deva has advised UN agencies, governments, national human rights institutions, multinational corporations, trade unions, and civil society on issues related to business and human rights. Professor Deva is also one of the founding editors-in-chief of the Business and Human Rights Journal, and he researches in the areas of India-China constitutional law, international human rights law, sustainable development, climate change, and gender discrimination. Shall we turn it over to Surya, or shall I continue with introductions and then turn it over to you, Stephen?
Should we start with Surya? I think
that's what I was thinking.
We've done it. Yeah, good, excellent.
Over to you, Professor.
Thank you very much. Thank you very much, Scott and Stephen. It's my great pleasure to join this webinar to launch this report, which is not only important, but very timely for a number of reasons in my view. First of all, this report attempts to connect the dots in terms of a range of governance challenges that we are facing, not only in Asia, but globally. The challenges relate not only to the issues like forced labor and modern slavery, but they also relate to other issues about data security. In Australia, we just had a massive hacking of data by this telecommunication company, Optus. So these issues are global and live, and they're happening everywhere. And of course, there are wider challenges to rule of law and judicial independence that are faced not only in Asia, but across the world. I think the webinars that preceded this report are also critical because they try to bring together the global North and the global South voices together. And the challenges that we are dealing with and talking about cannot be resolved with only some people and some actors. We need collaboration, and we need collaboration at a scale and at the transnational level, because the challenges are interconnected. It is also vital that the report highlights and underscores the role of non-state actors in dealing with some of these challenges. And 2 organizers of this event, BHRC and ABA ROLI, these are also an example of non-state actors in my view. So how could we harness the power of not only states, but also non-state actors, from businesses to lawyers, to bar associations, to investors and consumers, to further rule of law globally, is definitely a challenge that we are grappling with, and I think we need to come together. Now, in my brief remarks, I would like to focus on 2 aspects. First, I will talk about the brief context within which the section of the report on forced labor and modern slavery is situated. And I will talk about, secondly, what needs to be done differently going forward, what needs to change if we have to deal with the challenges of forced labor and modern slavery, in particular in Asia. So let me start with the context. And in terms of the wider context, the report sets out a number of things, but I will just pick 4 elements which are crucial in my view. The first element is we should see forced labor and modern slavery as part of wider governance challenges that we are facing in Asia or globally. if I can say that. These issues are there with us because of poverty, inequality, the shrinking civic space, and other challenges about lack of accountability, the power imbalances that we have in society. And that is where I will suggest that we should see modern slavery and issues about forced labor as merely symptoms of wider systemic fundamental challenges in societies and our free market economy, in fact, if I could add that. The second issue of context that I would like to highlight is that we should see Asia as the center of the problem. It is a center of the problem for a number of reasons, not only because of the population of the world that resides in Asia, but also the number of people who are trapped in forced labor and modern slavery who are living in Asia. But we should also not ignore that Asia is not only within Asia, Asia is also in non-Asia. What do I mean by this? We have many Asian workers who are working in Europe and trapped in modern slavery. So we should see Asia as part of that as well. As part of my working group role, I had the pleasure to visit Italy, a G7 country, last year. And in Italy, I found thousands and thousands of workers from Asia trapped in modern slavery in the heart of Europe. So issue is definitely about Asia, but it is not merely physically located in Asia. So we have Asian workers getting exploited in the West, in the global North. And I think that's where the issue of is that Asia is center of the problem somehow, but can it also become the center of solution? And I think that is what I would like to suggest, that we of course need action on the part of the global North and Western democracies to deal with the issue, but we also need to articulate the Asian responses. What works in Asia? What are the local conditions? Let us say informal economy, which is very vital. So how can we grapple with the challenges of forced labor, modern slavery in the informal economy? The third context that I would like to highlight is the COVID-19 pandemic. And it is unfortunate, and this is confirmed by a recent report released by ILO, IOM, and Walk Free. The number of modern slavery victims has in fact increased, unfortunately. So instead of making progress, we have moved regressively backwards because the number has increased in the last 4 or 5 years, and the COVID-19 pandemic has played a key role in that. And the fourth issue of context that I would like to highlight is about civic space, which is shrinking. How can we deal with forced labor and modern slavery if media and journalists cannot do investigative journalism? How can we talk about forced labor and modern slavery and overcome them if civil society organizations and human rights defenders and trade unions cannot do their work in societies? And here we are not merely talking about an authoritarian country like China, but I see worrying signs even in democratic countries like India and Philippines. And this is definitely a matter of concern for me because I come from one of those countries, India, myself. Now let me move on to highlight what needs to change. And I would invite all the participants and others to look at the recommendations of the report. I will not repeat all of those recommendations, but if I could highlight some key elements that are there in the report, some more explicitly, but some could be in implicit manner. The first thing that I would like to highlight is that we need better laws and more effective implementation. One may think that modern slavery is an issue that is already dealt with in legal regimes adequately, but that may be far from true. If we look at the legislation in UK and Australia, or even the draft that is being proposed in Canada and in New Zealand, the legislation are far from effective. They're very weak, in fact, if I could say that. And of course, the implementation of those legislation at the domestic level or even otherwise legislation in different countries in Asia is definitely very weak. The second issue is, how do we deal with state-sanctioned or state-tolerated situations of modern slavery and forced labor? And a very good case study here is Xinjiang in China. How can we overcome the challenge of forced labor and modern slavery that is faced by Uyghur community in Xinjiang in China? Especially when the government is adopting this policy as part of their government policy, and of course justifying it that this is correct. After a lot of delay, the Office of the High Commissioner for Human Rights released a report at the end of August. That report was long overdue, and when I was part of the working group, we issued a number of communications to China inviting us to visit. That has not happened. Now report is there, but I'm not sure what will change on the ground merely because of the report. So more needs to be done. And I think that is where extraterritorial obligations may become relevant. What can other countries do in relation to those particular situations where states are complicit in those abuses of serious nature? The third issue that I would like to highlight is transnational collaboration. Modern slavery, forced labor issues in a global economy are not merely confined into the border of one particular country or jurisdiction. So how can judges, lawyers, enforcement agencies, prosecutors, government officials, how can they collaborate seamlessly to deal with this particular issue? That's a major challenge. And I think Scott rightly pointed out that we can't merely rely on black letter law, and that's where the soft standards are crucial, especially in the field of business and human rights. How we can harness the power of soft standards like UN Guiding Principles, the OECD guidelines, and the ILO declaration to encourage businesses to take these human rights responsibilities seriously. But I would say we also need to invoke other levers of change which are there in the free market economy. These are consumers, for instance. These could be investors. Can we have a system in which every product that you buy has a label, and that label indicates how much wage is paid or received by the worker to make that pair of jeans? And of course, we can also include information about climate change. What is the adverse impact in terms of the gas emission of that particular product that you're buying? So how can we make consumers aware of it? How could we make investors aware of it, that the profit they think they're making, that could be based on the exploitation of workers and children in different parts of the world? The report also rightly highlights the role of the lawyers and law firms and bar associations and law societies, in my view. Lawyers can be a lever of change because they exert tremendous amount of influence, not only in politics, because many lawyers are part of parliaments and executive in different countries, but also because they advise private sector companies. So how can these lawyers be part of the solution and guide businesses to do the right thing? And of course, let me conclude with access to remedy and accountability. Prevention is desirable, but prevention is never foolproof. It is inevitable that there will be adverse impacts of business activities, and there will be situations of child labor and modern slavery and forced labor. That is inevitable, despite whatever we try. How could we ensure then that those people who are trapped, they are able to have access to remedy? And accountability is there, because if the actors, whether these are businesses or government officials, if they are held accountable for their action, and they're not able to allow to benefit from exploitation, then I think that is going to send a right message. And I think in this particular context, we also need to be aware of the differentiated impact that these concepts have on women, children, migrant workers, persons with disability, and so on and so forth. So our responses should not be seen as kind of monolithic. Everyone is the same. No, these victims are different. And there is often an element of intersectionality as well. Race and religion may also play a role. It is not a coincidence that the people in Xinjiang are part of ethnic minority. This is an issue about intersectionality, the power imbalances that are there for these victims. So thank you very much for giving this opportunity. It has been my pleasure to be part of this project and the report. And I look forward to listening to my distinguished panelists and look forward to further collaboration. Thank you very much. I pass it back to you, Scott and Stephen. Thank you.
Thank you so much, Professor Deva. And I'll toss it over to you now, Stephen.
Thanks so much, Scott. Before we move on, I just wanted to say that we've got a chat function on this call, and we're hoping to have a half an hour or so, at least at the end of Q&A, and all our speakers are staying on in the hope that they'll have answers, they'll have questions to answer, I'm sure. And so if you want to use the chat function, it's there, and we would be delighted to hear any points you've got to make or questions you want to ask. So our next speaker for me to introduce is Professor Felicity Gerry KC. She's an international QC at Libertas Chambers in London and Crockett Chambers in Melbourne, largely defending in serious and complex criminal trials and appeals, and often with an international element. Felicity is one of the few women silks to defend in a terrorism trial, and has also advised in relation to death penalty matters in Indonesia and Philippines, and on citizens held in Syrian camps, and on complicity in international criminal cases. Felicity is the honorary professor at Salford University in the School of Health and Society, where her research focuses on autism and criminal law, FGM law and child rights. She's also the professor of legal practice at Deakin University, where she is unit chair for contemporary international legal challenges over. Sorry, I'll start again. She's the unit chair for the contemporary international legal challenges overseeing modern slavery, terrorism, war crimes, and climate change law. And Felicity is going to speak to us about sanctions today. Thank you, Felicity.
Thank you, Stephen. I had an awful thought you were going to start from the beginning and use up my introduction and all my time, but I'm very grateful for the introduction. I'm speaking to you all from the Northern Territory of Australia today, so I'd like to acknowledge the First Nations Larrakia people on whose land I am currently sitting, and pay my respects to their elders past, present and emerging. I'm delighted to join this launch event. I participated in the roundtables specific to sanctions. I'm very pleased to join in the writing of the executive summary and have the opportunity for an advanced read of the report that's being launched today. And I applaud the Bar Human Rights Committee and our American partnership for this engagement on these issues in Southeast Asia in particular. I want to pick up on what the last speaker said before I come to the specifics of sanctions, on how it is to listen. We've used that word in the report, in the title of report, and the listening and working together of lawyers, NGOs, policymakers, academics, in my view, has been absolutely crucial in the way in which we can develop our approaches, post-colonial, hopefully, approaches, or neo-colonial, depending on what your historical knowledge is or your position is, as to how we can embed human rights in what we do. And of course, in many of the Southeast Asian countries that I've worked in, there are constitutional and human rights laws that are far beyond those written down in England and Wales. So that we have a lot to learn from the legal frameworks that there are across Southeast Asia, and I particularly enjoy working with academics and doing research in those areas. That brought me, of course, to work on sanctions, which is very much the intersection between criminal and commercial law. So again, a thank you really to Stephen and Louise for bringing me on and giving me an opportunity to talk about one of the greatest moments in my career. as barristers, we always like to talk about those. So I'm going to tell you a story rather than a lecture on sanctions. And I will in a moment put in the chat the result of that story. But as a result of the work that I've done across Southeast Asia, I was asked by an NGO and campaign group to get involved in a situation in Myanmar, and I was instructed by the Australian Centre for International Justice to draft a memo in relation to a proposed construction in Myanmar called Golden City. So essentially, the story is that Emerging Towns and Cities as a company were seeking to list the investment opportunity in Golden City on the Singapore Stock Exchange. And 2 reports had been done by some analysts, let's put it that way, that suggested that there was something okay about these investments and they could be listed on the Singapore Stock Exchange. And I was really asked, was this correct? Now, the way in which we decided to approach the memo, and I'm going to give you a link to it because it's quite long, was to really assess risk, to talk in the language of the stock exchange. Now, the system on a stock exchange is you apply to list, and you also have to have a sponsor. So there are some frameworks around which risks are assessed by the stock exchange itself, by the sponsor, by the company seeking to list the investment. And there are risks at every level, including in relation to sanctions. And it struck me as we were considering the way in which we were going to approach this memo that we knew would be public in the end. So it wasn't going to be a privileged document. It was very, very important to speak the language of the investor, but in a way that would fulfill our instructions by the community and the activists who needed to know where they stood. And the serious concern was that the investment that would come through the Singapore Stock Exchange listing would inevitably place profits in the pockets, at least of an organisation that has been labelled a terrorist organisation, but in the pockets of the military junta in Myanmar. So the framework that we were working in is a framework that we can recognise. Where's the money going to go? Is this the sort of money that's going to exploit people or indeed be in breach of international compliance, regulatory guidance? What does that all mean? So some of us become experts in modern slavery, and certainly that was part of my PhD. Some of us become experts in commercial risk. And we have an expression, certainly when I work in Australia, that everybody works in silos. So we don't the left hand doesn't necessarily know what the right hand is doing. And I think the value of the experience that I had in producing this memo was that we were able to break out of those silos and consider the risks in various ways to individuals who may be at risk of personal liability as directors, for being complicit in human rights abuses if this investment proceeded, to business entities who would be at risk of being in breach of sanctions. And the short version of this story really is that I like to think we were as comprehensive as we could possibly be. And I do encourage everyone to read our memo as well as reading the Edge of Law report, just to have a look at every single area that we tried to look at to say, well, look, will you be investing in something that will exploit people in terms of modern slavery? Will you be in breach of sanctions? And I'm absolutely satisfied that we were able to show that the reports that had been done thus far by the consultants were inadequate. They'd perhaps looked at the risk of the contractual arrangements as between the emerging towns and cities that were seeking to list this investment and the contractual relations on the ground, but they hadn't gone as far as looking at international risks. Now, the first question might be, well, is Singapore an OECD country or is Myanmar an OECD country? And the answer to those questions might be no. But of course, if you're calling for investment on the Singapore Stock Exchange, you might well have investors who are sitting in a country where the OECD guidelines do apply. So we spread ourselves across the world. Imagine it could be anyone sitting in any country. What are the guidelines? What are the risks? And the reason it's one of the greatest moments of my career really is because, first of all, emerging towns and cities applied for more time to respond to the memo by Felicity Gerry. So I personally caused that delay. I'm named in the application to the Singapore Stock Exchange to delay that that listing so that they could carry out further assessment as to risk. And I'm pleased to tell you that the listing has not gone ahead. As far as I know to date, that the Singapore Stock Exchange have, let's call it, got cold feet. Whether that's the correct description, I don't know, but it's a shorthand version of at least telling you why I consider it to be a great moment of my career. But I also consider it to be a learning curve, because I had to learn the situation of the people on the ground who really wanted to know where they stood in terms of these types of investments, but also to learn the language of commercial lawyers who are working in different areas of commercial law as to how we might speak as to risk, and then also learn the language of business to say, well, hang on a minute, are you really going to advise anybody to invest in this particular opportunity? So in terms of sanctions, which I know was other than telling my story, of course, I know the topic that I have is sanctions. I think sanctions was the key to those cold feet. I'm not going to say for a moment that it was all of our memo or necessarily that all of our memo caused a concern, but sanctions are a key element to this global compliance mesh that businesses have to operate within. And the sanctions create a fear factor for investors. Are you going to be in breach of international sanctions is a serious question that needs to be answered. And in our view, that was the clincher, if you like, of the risk problem for a stock exchange that doesn't always have the greatest of reputations in the types of listings that it has. So just thinking about sanctions in that way, and when we're looking at domestic legislation that is now moving across the world for Magnitsky type legislation in which we seriously consider human rights abuses in the way in which we approach our business operations, and in the way in which we think about where might the remedies lie. In my view, sanctions is key. It doesn't necessarily sit alone, but it is key to us recognizing that corporates have an enormous role to play in the implementation of human rights compliance. Even if you call it something else, it's about the non-exploitation of people and not putting people at risk, but speaking the language of corporate risk. So that's a story that I wanted to tell. I think I was also very pleased to be able to engage with all of the experts that took part in the formulation of this report. And what I thought was really important, and I suspect I'm coming up to time now, so I won't go on for much longer, but what was really important was the round tables that have led to this report, that we all discuss. We didn't just sit there telling a story, which I'm doing for the purposes of this launch, but we all discussed, how does this global compliance mesh work? What can we do to engage supply chains in this global network of business operations, and how can we talk each other's language so that human rights doesn't become some sort of outlier, but it is embedded in the way in which we do business across the world. And we, in the course of all of that, we learn to speak the language of the criminal lawyer. And if I want to wave a flag for the criminal lawyer on occasions, today I think was the day to do it. And it was really valuable for me to have had that criminal law experience, to be able to see what the risks are, without ever giving advice. I never gave advice. It's a memo. I'll pop it in the chat. But I'm delighted to have been able to use my story to great effect in my contribution to this fantastic report. Thank you very much, Stephen. I hope telling a story is what you wanted, and I look forward to the Q&A.
No, thanks so much, Felicity. That's a fantastic practical example how threat and sanctions and how they fit into the, as you called it, the global compliance mesh. I think it's a good phrase for today. Right, I'm going to hand back to Scott now. Thanks, Scott.
Thank you. Well, I have the pleasure of introducing Nighat Dad. Nighat Dad is the Executive Director of the Digital Rights Foundation in Pakistan. She's an accomplished lawyer and a human rights activist. Nighat Dad is one of the pioneers who have been campaigning around access to open internet in Pakistan and globally. And she has been working and engaging at the policy level on issues focusing on internet freedom, women and technology, digital security, and women's empowerment. Ms. Dodd has been recently included in the Next Generation Leaders list by Time magazine for her work on helping women fight online harassment. And she is a member of the Meta Oversight Board. And I believe Meta is the new name for Google. I can be corrected if I'm wrong. And lastly, before I turn it over to Nighat, just a point of order here. If you have questions, please put those in the Q&A. And if you want to share some information, of course, or a link to something, feel free to put it in the chat. Over to you, Nighat.
Thank you so much, Scott. So Meta is basically the new name of Facebook and Instagram.
Oh, sorry. I knew I was going to mess it up.
No, it's. I think we are going into the world of metaverses, and all these big companies are now creating their own metaverses. While we. Through this report, we are trying to create our human verse. So coming to the report, basically, I personally believe because, and also I participated, in one of the virtual conversations. This is a great initiative to capture the rich discussions and dialogues that have been taking place through not only in Asia, but also in the global north. And I think what BHRC and ABA has tried to do that, it's to bridge the gap between global north and global majority and the conversations that have been happening in silos. It brings together different perspectives from different countries, from South Asia, Southeast Asia, and centering that shared language of human rights and rule of law, but at the same time paying attention to the ways in which they play out in different contexts. And I'm particularly pleased that space has been given to a nuanced discussion on data privacy, digital surveillance, and everything that is related to the right of privacy, especially how it is being understood by the people in the Asia, at the same time by the corporations and the governments. Reading the report, the first version, I mean, before the launch, definitely, I found confluence between all the topics, the interplay of discussions around sanctions and regulatory frameworks that actually also fed into the discussion on data privacy quite well. And the report's strength is that it focuses on the law, while at the same time including perspectives from human rights defenders and activists. And I myself, as a digital rights activist, and working for more women's rights, I feel this is a beautiful combination. And the topics that have been discussed and the recommendations that this report contains are grounded in real world realities and capture a diverse set of experience. So it's not something that the report has been written in silos, but it actually capture diverse opinions, people working on the ground, at the same time people who are in the field, who are the experts, and then beautifully combine them in this report. And so coming to the topic that I was basically part of, the virtual dialogue brought together experts to discuss, the ideas around right to privacy, but also it gave us a time and space to deep dive into the legal perspective of data protection. We also looked into the legal interventions that are required, nuanced approach that brings together legal protections and accountability mechanisms around UN guiding principles on business and human rights, and of course OECD that my earlier colleagues also spoke about, but the OECD due diligence guidance for responsible business conduct as well. And what we have noticed that there is a dire need to open up the framework by taking measures to make the process of imposing targeted sanctions more participatory in order to ensure legitimacy of the process, but also fairness in application. And inclusion of civil society organizations in the process is a start, but needs to be institutional. All right, so this word is something that I cannot really utter. But anyways, the civil society organizations should really be embedded in order to be effective at a structural level. And the dire need is to address the perception of double standards when it comes to the use of sanctions to prevent it from becoming a blunt instrument for achieving foreign policy objectives rather than a tool to ensure international human rights compliance. So when we were talking about data protection, we noticed that the language of security is used to construct laws around militaristic anxieties, and using the prism of national security to ensure data privacy. We noticed this especially coming from Chinese militarization of daily life, and what we have noticed that rather than centering all these regulations on human rights, they are centered around this vague concept of national security. We noticed technologies give basically permission for unprecedented levels of surveillance and data processing, and which has basically called for regulations around cross-border exchange. We looked into how UN has addressed this challenge through UN special rapporteurs on freedom of expression and their submissions and different mechanisms at the UN. And we also sort of looked into emerging challenges faced by the judiciary in relation to technology issues, that how they require consideration, particularly in our context. In our context means Asian context. And I, as somebody who has been working on this space for more than a decade, speaking from experience, the judiciary is slow to adopt to emerging technologies, often resistant to changes, and something that we have given in the recommendations, cited in the recommendations, that there is a dire need for education of the judiciary regarding technologies, particularly technological issues such as artificial intelligence, machine learning, and automated decisions, and how they should be considered while making decisions around such around relevant cases. We discussed different legal frames in Asia around digital privacy, but also we looked into the cultural nuances and differences and jurisdictional differences. We spoke about data ownership and privacy interests. We spoke about how national security plays out. We also looked into where the jurisdictions where data protection laws are already enacted, but how those are being implemented and the challenges that not only the governments are facing, but how those laws are being weaponized, although they are the protecting mechanisms around data, but they are being weaponized against the users. We spoke about the oversight of data practices at the government level, but also the industry and corporate oversight as well. And looked into the international standards like self-regulation, especially the standards like Global Network Initiative and in industry self-regulation initiatives like Meta's Independent Oversight Board. So I'll end it here, but I really hope that this report will actually give a flavor to the folks who are looking into the issues around all these different themes which are very well connected to each other, from the independence of judiciary to the data protection and other themes that my fellows have spoken about, to look into what exactly is happening in Asia. And while we have given recommendations for the lawyers and how they can use this report to, like bring into their practice, especially like new concepts and new ideas around data protection and emerging issues around technology, this report, I feel, is a starting point for them to bridge the gap, what is happening in the global north and how those good practices not all are good practices in global north, but how those can be brought into the global majority, especially Asia, and use it in their practice. So I'll end it here, Scott, and I look forward to the questions from the audience. Thank you.
Thank you so much, Nighat. Back over to you, Steve.
Thanks so much.
Oh, sorry.
Hi, sorry. Hi, Desi.
Hi.
I'm just going to tell people who you are, if that's all right. I'm sure they all know, but I'll do it anyway. Desi Hanara is an international human rights practitioner. She's our next speaker, and she has more than 10 years professional experience in the sectors of human rights, international law, and international relations from within and outside the ASEAN system. She is currently overseeing ASEAN external relations with the ASEAN Political Security Department of the ASEAN Secretariat. She is widely published on human rights mechanisms in ASEAN and Asia and freedom of religion, and has previously served as a regional coordinator for, I'm not sure how to pronounce this, IPFORB's project in Southeast Asia, undertaken in partnership with the APHR. And I think Desi is going to speak to us about the Judicial Independence part of the report. Thanks, Desi.
Thank you, Stephen. Thank you, Scott, for the generous introduction. First of all, I would like to extend my appreciation to the esteemed organizers for inviting me to report on the key highlights and recommendations from Session 4 on judicial independence, the rule of law, and the role of the legal profession. I will also take the opportunity to share my views on the ways forward to achieve judicial independence in the face of threats to the rule of law, and try to examine how judicial independence, integrity, and impartiality can become more deeply rooted in the legal institutions in the Asia-Pacific regions. So the report highlighted some of the key challenges in judicial independence and rule of law in Asia. It's probably have been mentioned. The report, mentioned that the challenges in each country are complex and deeply entrenched. The judiciary has been under attack across the region. Military rule, emergency decrees that invoke national security, eclipse of the rule of law, corruption, and authoritarian disregard for the separation of power doctrine. In Hong Kong, for instance, the judiciary has recorded abusive gravity, doxing, and even death threats against judges to insult and intimidate them for having decided politically controversial cases in a particular way. So there are also some challenges with regard to the legal framework, and I would really like to emphasize on this. While the international law treaties and conventions, as well as principles, have stipulated and outlined the framework for the independence of judiciary, as well as the interlink between a competent, independent, and impartial judiciary and the protections of human rights. However, the Asia-Pacific region lacks a binding human rights instrument, as well as enforcement and supervisory mechanisms, including a regional human rights code, a cohesive communication mechanism, or reporting procedures. This has serious implications, as highlighted in the report, for the realization of human rights standards and for the creations of a human rights culture in the region. The judiciary in the region, in comparison to judiciaries in the other part of the world, is neither equipped nor supported in their adjudication of human rights matters at the regional level, nor in the delivery of recourse and remedy for the victims of human rights violations. When it comes to judicial institutions, one of the esteemed speakers from our session, Professor Hong Lee, pointed out a number of challenges, which include inconsistent, incohesive, and opaque judicial appointments process in some countries, and the flagrant endemic manipulation of these processes. Other issues include a lack of security of tenure of the terms of the judicial office and a lack of protection against retaliatory diminution of judicial remuneration, both of which ultimately undermine effort to adhere to international anti-corruption standards. So another challenge include wrongful interference with a disciplinary and removal procedure for judges. As Professor Lee observed, it's relatively easy to manipulate the judicial appointment process in the Asia-Pacific region because vastly different systems for judicial appointment have been adopted in different countries, and there's no transparent, recognizable regional standard to benchmark. Similarly, the judicial removal processes in the Asia-Pacific countries are overwhelmingly susceptible to abuse. Again, I would like to quote Professor Lee. He recalled that in 1988, 3 judges of the Supreme Court of Malaysia were controversially removed on the grounds of the misbehavior in telling criticism of the executive. So the report also highlights the issue of judicial independence and separation of powers. The judiciary in the Asia-Pacific region encounters a crucial dilemma, which arises from the invocation of constitutionalized emergency powers and the power of preventive detention. At this instance, the court had little room to maneuver, as the report highlighted, as the constitutional provisions embodying the emergency powers expressly restrict the scope of judicial review. This has occurred in the case of Malaysia and also Hong Kong, as has been summarized in the report. And other distinguished presenter, Sarah Macquarie, highlighted the salient point, but it has been largely underexplored issue on how gender discrimination and sextortion are undermining judicial independence in countries in the Asia-Pacific region. So in addition, the report also highlighted the findings of GIN ASEAN and UNDP research focuses on various kinds of technologies used in the courtroom and the administration of the court. The findings, among others, indicated that many judges do not actually understand or are overwhelmed by the emerging technology, which is problematic because judges must not only have the confidence in technology use, but they must be able to convey such confidence in the public, so as to ensure adherence to the rule of law and to open justice principle, and demonstrably meet obligation to guard against individual right violations. Another interesting trend found in the research indicated enhanced accessibility of the court to larger numbers of people, especially people who are vulnerable due to gender, sexual orientation, race, refugees, or displaced status, including people with disabilities, people who live in poverty or in remote areas, and those whose identity or political participation puts them at risk. So as we can read in the report, the research resulted in 9 recommendations to judiciaries focused on strengthening judicial excellence using new technologies and emphasize the importance of incorporating rights protections into the design and development of new technologies from the earliest iteration. So of course, the report also touched upon the issue of judicial independence in common and civil law system, where speakers from our session highlighted the blanket applicability of Bangalore principle in both civil and common law jurisdictions, and underlined the need to promote the principles further as widespread adoption and implementation at the regional level remain to be seen. So with regard to the ways forward, the panel presenters at session 4 anonymously recognized that the Asia-Pacific region is not a monolith, and that the rich diversity of races, languages, religions, and cultures make it difficult to prescribe an overarching one-size-fits-all solution to attain an effective and impartial functioning of judicial institutions, encompassing procedures, protocols for judicial appointment, security of tenure, independence and integrity, as well as removal. So this session has delivered a conclusive recommendation for strengthening judicial independence in the Asia-Pacific region, as can be found comprehensively in the report. The recommendations are tailored to include the action lines regarding the international standard, regional standard, and also stakeholders' engagement. So I would like to highlight some of the key recommendations. There's a need to disseminate international instruments such as UN Basic Principle of the Judiciary and the Bangalore Principle to provide guidance to judicial communities seeking to strengthen their judicial institution. And Asian Pacific countries should take steps to ensure that international rules and standards aimed at dealing with the issues of judicial independence are integrated into domestic law and applied by domestic courts. And with regard to the role of professional bodies such as Bar Association and International Human Rights Organization, they should include providing a check on any erosion of judicial independence. Bar Association and civil society should consider necessary intervention, such as systemic scrutiny of rule of law when a threat to judicial independence occurs. And members of judicial and legal communities, as well as representatives of law societies, Bar Association, and civil society, should also urgently address gender imbalance in the judiciary. And of course, as highlighted before, there's also recommendation with regard to the strengthening of the role of the judiciary in the technological change. So finally, I would like to take this opportunity to reiterate the point that in order for the judicial independence, integrity, and impartiality to be rooted deeper in the legal institutions in the Asia-Pacific, such practice needs to be nurtured together with the effort to mainstream and strengthen human rights in the region. The guarantee of fundamental freedoms to members of judiciary is a must, including freedom of expression, belief, association, and assembly. The judges shall be free to form and join associations of judges or other organizations to represent their interests, promote their professional training, and also protect their judicial independence. There's also a need for the Asia-Pacific region to have a binding regional human rights instrument, as well as enforcement and supervisory mechanism, including a regional human rights court, a communication mechanism, and a reporting procedure, so as to allow the judiciary in the region to have adequate mandates to adjudicate human rights matters at the regional level, so as to serve as a regional recourse for the victims of human rights violation whose own states have failed to protect them at the national level. There's also a need to strengthen the regional bodies, including Association of Asian Constitutional Court and equivalent institution, as highlighted in the report, which in the past has issued Bali Declaration on the promotion and protection of citizens' constitutional rights. The declaration encouraged the practice of judicial independence among its member countries and considered necessary intervention when a threat to judicial independence occurs in any of its member countries. So furthermore, ASCC and other regional bodies, such as regional ASEAN chief judges, can serve as a strategic platform to discuss and consider the feasibility of the establishment of Asian Human Rights Court and the development of binding regional human rights instruments. And finally, the 2018 report of the Special Rapporteur on the Independence of Judges and Lawyers underlined the importance of the establishment of a judicial council to guarantee the independence and autonomy of the judiciaries. So countries in the Asia Pacific should encourage the establishment of judicial council or similar independent institution where it has not been created, and improve the standard of those already in existence, especially in relation to the creation, composition, and the roles of judicial council. With that, I will end my presentation, and I look forward to further discussion during the Q&A session. Thank you. Over to you, Scott and Stephen. Thank you.
Thank you very much, Desi. So that's summary of what we've got in the report on judicial independence, which is very much worth the readers, are all the contributions in the report. Now, for the rest of the session, we've got some time, and we've got some time to ask the speakers some questions. We had some questions sent in before we started, and we've got a couple of questions I can see as well. So we'll ask the speakers some questions, and then when we finish that, what we're going to do is invite each of our speakers to just contribute a last thought in a minute or so at the end of the session, and then we'll then close the seminar at that point. But so far as questions are concerned, I think I'll start off with a question which is aimed at each of the speakers in turn. And I'm going to ask the speakers on the basis of the areas that they've concentrated on today. And the question is, in your experience of the area you've spoken about today, what do you think legal practitioners should focus most on in their everyday practice? And I'm going to go to people in the order that we've spoken today. So, Surya, first of all.
Thank you, Stephen, for the question. As I noted, that legal practitioners play a key role in advising businesses, and businesses are quite closely connected with issues about modern slavery and forced labor. And if lawyers can provide advice, not only about the legal risk, but I would suggest also about the market risk. And sometimes that advice is not based in black letter law, but it is based on the other factors that are crucial for businesses to keep in mind. And if they can provide that advice to their clients, to businesses, I think that should definitely help going forward. I will also suggest that lawyers and law firms, they also need to reflect internally about their practices in terms of what advice they're giving and to what extent that advice has adverse human rights impacts. Because of course, lawyers have a duty to protect the interest of the clients. At the same time, they also have to ensure that this duty is not undermining equally important public policy considerations, including promoting respect for human rights, in my view. Thank you.
Thank you, Felicity.
Hi, sorry, I was just, after 3 years of being in lockdown, I was still struggling with the mute button. You'd think we'd get over it by now.
Right.
Look, I think my whole practice has always been not necessarily what the law is, but what the law should be. And I know that that could be interpreted in many ways, and I can only go on what I think it should be. And there's a moral element to that. And when human rights defenders are particularly under attack, I think it's really important that we learn to use the skills that we have to the greatest benefit. And as a criminal lawyer originally, I always thought that what I wanted to do was a murder trial in the Old Bailey. And when I got there, I realised there was a world elsewhere. I had my Coriolanus moment. And I think business and human rights is where it's at, that for a criminal lawyer. And if I've got one thing that I would ask any lawyer to do is not work in that silo. I use compliance mesh deliberately. It's a phrase from academia. I did the research as part of my master's on global governance. My spouse works in quality compliance. So it's something that I feel criminal law has real effect across the business and human rights agenda. That's not to suggest that we should be criminalizing corporates, but that there is a lack of understanding that we can have of the way in which criminal law can work in the business and human rights context. And so I can now call myself a human rights lawyer, if I like, but that's a slightly garbled way, post jet lag way of saying, first of all, don't work in silos. Secondly, recognize your skills as a lawyer. Thirdly, donate those skills to those people who need it. We did it for a campaign group, NGOs, people who don't necessarily have the funding. And thirdly, stand up for human rights defenders. You know, that's what we are. And when we're under attack, particularly as defense criminal lawyers that are almost in the same boat, then stick your head above the parapet and stand up and make a noise. It's what I try and do all the time. So I'd encourage others to do the same. And I must say, I've found it very rewarding. So for those of you who also feel your careers may be stagnating down one particular path, it's another way of turning your career around and keeping you excited about what you do on a daily basis and feeling like you're making a difference.
Thank you for that pep talk for us all. I'll go to Nighat now.
Yeah, thank you, Stephen. There is this one question which I believe has been addressed to me. It's basically asking what emerging technology is being identified in relation to judicial resistance. And I think in our conversation and in the report also, what we have noted that the judicial resistance, it's not particularly in terms of any specific technologies. I think it's a lack of understanding of these technologies, especially the emerging ones, and also adoption of these technologies. It's not intentional resistance by the judiciary. I think it's basically how they can adopt this, and who are the people who are assisting them in adopting these technologies to make their work better. In terms of the role of lawyers, what we discussed basically that data protection and digital privacy are the subject that are emerging and continues to evolve. And what lawyers and bar associations can do, they can play actually really important role in building broad understanding and implementing a really purposeful approach to data that protects individual users' right. They can influence data protection and digital privacy in preventative way, in reactive, depending on their role. And also as policymakers, lawyers can draft legislations with clear purposes to minimize misinterpretations or avoid strict interpretation, which certainly can help the legislative goal and helps judges and regulators to understand the purpose of the law. I think this was something that we have also noted in our conversations. And when lawyers advise companies, do due diligence from a legal perspective, but also from an ethical and privacy perspective, to focus corporate practices on more than the minimum requirements, and on privacy approaches that reflect a company's standards, which helps its consumers. So I think overall what lawyers can do is to build, their own knowledge around these emerging issues, but at the same time, centering the international human rights framework on these issues and looking into the international best practices as well as the UN guiding principles on business and human rights, I think should be the start. And I also see how bars and judicial academies can play a role to not only educate lawyers, but judges as well.
Thank you. Thank you for that answer. Desi, have you got any points you'd like to make for lawyers and what they should be concentrating on in their everyday practice? I'm sure you have.
Thank you, Stephen. So mostly it's just echoing what had been said. So I do agree that lawyers should stand up for human rights. They should do more pro bono work when it comes to defending the human rights defenders, because most of them are not financially, able to seek legal aid. So I think the pro bono work, like the case of my lawyer friends in Malaysia and Indonesia, it's been really helpful for human rights defender to take forward the work they're doing with regard to human rights. And I think I do agree with the fact that lawyers should not work in silo, because they need to also engage parliamentarians when they want to seek amendment for the law, for instance, because parliamentarians hold this authority to when it comes to lawmaking. So they should do cross cross pillar, I would say, engagement between parliamentarian, judiciary, and also executive branch, because a lot of things are happening on the executive branch, and lawyers should also proactively, look toward the opportunities for advocacy from within the system of the status quo, for instance, in ASEAN, for instance, or any other regional bodies in the Asia Pacific. So thank you.
Thank you very much. I was going to ask you about the other question, which I think Nighat's just answered as well, which was, I think, something you raised in your talk about new technology and judges and the problems that some judges have with embracing that. And I just wondered, I think the question was asking for examples of what it is that judges have problems with, and what perhaps we should do about it.
Yes, I think mainly, with the use of digital technologies, based on what was presented by the presenter at that time, like we're using a lot of, online platform, we are adjudicating cases through online platform, and judges who may be, more senior when it comes to age, they might not be very familiarized with all these new technologies in the courtroom. So I think it's also important to increase the familiarity of judges with the use of the new technologies, as has been indicated in the report as well. So, and also to introduce to them the value added of the use of these technologies, as I mentioned earlier, that because it increased the accessibility to minorities, gender minority, religious minority, and so on and so forth. So recognizing that value added, I'm sure the senior judges would be more receptive to the digitalization in the courtroom. Thank you.
Thank you very much. Scott, I think you've got a question or two.
Yeah, if I might just follow up with you, Desi. In the Edge of Law dialogue and elsewhere, I think it was you that recommended the establishment of some sort of platform to enhance human rights expertise in the judiciary itself. And I wonder if you could share with us some of your thoughts on how we might best make something like that happen. And specifically, what can the legal profession and the international community do to support this type of human rights education and training for the Asian judiciary?
Thank you. Thank you very much for the question. Yes, in one of my paper, I identified that there's this body that I mentioned, the AAC. So basically, this body has established technical resource center to provide technical expertise and assistance to policymakers, judges, and lawyers. And this is an an association of constitutional court across Asia Pacific region. So I think it would be a good idea to tap into the resources that this resource center has. Right now, it has been established in Seoul. Its name is Permanent Secretariat of Research and Development. If we recall some of the decision from this AASC Board of Members meeting on August 2017, he mentioned that the areas of work of the SRD included fundamental rights. So it would be good, with this framework, we can use it as a mean to enhance the human rights expertise of our judiciary. And in addition to that, I think it's really important to disseminate and also conduct training or workshop based on the existing manual that have been established that have been developed by a number of institutions, for instance, OHCHR, or even Bar Council and ABA ROLI, in order for us to give comprehensive and substantive training, to legal professions around the Asia Pacific region. Because just to mention, for instance, OHCHR manual on human rights, it actually covered a lot of important principle when it comes to independence and impartiality of judges, prosecutors, and lawyers. For instance, human rights and arrest, pre-trial detention and administrative detention, the right to fair trial, international legal standard for the protection of person deprived from liberty, for instance, and many other topics that could be really useful for our legal professions when it comes to integrating human rights perspective in their legal practice on a daily basis. Thank you.
Thank you, Desi. Steve, do you have a follow-up question?
I think one of the questions we've got in the chat asked a question about how BHRC decides what to do and how to do its work, how to prioritize its work in some of these areas. And I don't think any of our speakers can answer that question today, and I want to concentrate on the speakers. But perhaps I can reformulate that question for the panelists. As what role do organisations from outside the Asia Pacific region have in supporting discussion and support of any of the subjects discussed today? What can groups from outside of the region do? I'll see if anyone wants to volunteer to answer that one.
Again,
Nighat,
respond to that.
Thank you.
Yeah. I personally, I have been a huge supporter of global North and global South working together, but I have been also very critical of the gap between both regions in terms of not only advancing the issues around digital rights or emerging technologies and regulatory framework, but also how in Western democracies the regulatory frameworks are being initiated and established, looking at their own jurisdictions, but then in the regions like Asia or global majority, where some of the governments are so-called democracies but are not really democracies and copy paste those laws, right? And then the impact of those laws and how those are being weaponized against the users. I think such dialogues and conversations and the kind of report that we have launched today is actually bridging that gap. And I think not only sharing the knowledge and the right kind of knowledge to inform practitioners in Asia to adopt best practices, but also at the same time how these practitioners can work together, you know, in all these regions and then work in their own context. And I think what we have tried to do this through these dialogues that not only looked into the challenges, but while giving recommendations, we contextualized those recommendations. So really didn't copy pasted or, you know, like brought those, you know, Western solutions into the conversation, but we said how we can contextualize it, given you know, the challenges in our own jurisdiction or the cultural nuances. So I think what you all have done and we as speakers have done and this report is doing is act exactly the same. And I think we need to do this more, not only with sharing of knowledge, but also sharing of resources as well with the civil society organization, because we have spoken about shrinking civic spaces as well during our dialogues.
Thank you very much, Nighat. Was there anyone else who wanted to have a go at that question? Felicity, thank you.
Yeah, just a couple of short points, really. One that comes from the report and one that, well, both come from the report, really, but that comes personally from me. I think this concept of listening that I mentioned at the beginning is so important, but also comes with learning. Those of us who, you know, I started out in England, I'm in Australia, we have this very Western attitude that we're always right and we're often wrong, and learning from other jurisdictions, and exactly the point that Nighat was just making, that we can really start to contextualize the problem and not assume it's a problem for a particular jurisdiction, I think is so important. This listening and learning exercise is so important. And one example that I can give you from our report is when we made the recommendations for bar associations in relation to sanctions, one of the issues that we thought about was calling for the removal of sanctions that offend the rule of law and human rights. So we didn't just look at sanctions as a mechanism for compliance in what we understand to be a world of compliance, but we also looked at our understanding of when these sanctions can go wrong and cause more harm than good. And that's really only ever going to come. You're only really going to understand the effect on the ground if you can speak to civil society in the way that we've just discussed. So listening and learning to make sure that you're not making assumptions about the way in which corporate compliance is approached, I think is just invaluable. Thank you very much. I have another question for Surya, if that's all right. You were talking about modern slavery, forced labor being fueled by poverty and corruption and weak governance. The question is, how do you make the link between social and economic inequality and modern slavery and forced labor more explicit? And I know you used the example of perhaps we should have a label on items which shows how much someone was paid to make a pair of jeans and that kind of thing. But I just wondered if you could perhaps enlarge upon that thought a bit further.
Thank you, Stephen. Yes, I think the link is there, but I think when the law and policy makers are operating, I believe they also operate in a siloed way, something that Felicity was talking about earlier. So let us say the modern slavery legislation may be led by Ministry of Labor. And then Ministry of Labor is thinking in a siloed, in a compartmentalized manner, and they're not looking at the wider considerations that are relevant about gender, about investment, about trade. So all these elements have a bearing on an environment which is either going to promote or discourage the opportunities for modern slavery or forced labor. And I think that is very crucial, that we break those silos even within government ministries that are shaping law and policy matters on these particular issues. I think that is quite crucial. Let me also bring in sustainable development goals here. So when we talk about sustainable development goals, and often in the context of modern slavery, we focus on 8.7. And there is an 8.7 alliance, but that is also a siloed approach in my view, because if there is a living wage paid to workers by companies and of course by government institutions, then that is definitely going to ensure that there is no forced labor or modern slavery. Similarly, if we have trade unions which are independent, that is also going to ensure that the modern slavery is eliminated, because those independent trade unions can enhance the address the power imbalances and deal with the rights of the workers better. So I think those are the connections that I think we need to make in terms of law and policy going forward. Thank you.
Thanks. Scott.
Thanks, Steve. I've got a question for you, Nighat. And since I'm obviously not the most technically hip, I can't keep track of Facebook's current name. Feel free to elaborate and share with us your thoughts on this. I know that Facebook and Google are working behind the scenes on a lot of artificial intelligence applications. And I'm curious, what, in your opinion, what are the implications of sort of new data privacy and protection laws in the region on these AI innovations and other data intensive applications that we're seeing proliferate?
Yeah, Scott, this is a very important question. So in these emerging technologies, especially that those are based on AI and machine learning, pose really unique challenges to privacy. The application of these technologies permit for unprecedented data processing, collection, and sharing. And these conversations, what we believe is really need to be tied to calls and regulatory frameworks which seek transparency and accountability for such technologies. Many privacy laws, such as the GDPR in Europe, for instance, specifically do not deal with artificial intelligence directly, which means that the unique risks or risk of unprecedented data aggregation and processing are often not adequately addressed. At the same time, GDPR has been set as golden sort of rules or principle for data protection. So the governments in Asia are actually adopting GDPR, while they are also working on the legal frameworks around data protection in their own jurisdictions. But there have been calls from the EU. For instance, there was a draft on AI Act, which could actually set the gold standards for the rest of the world. But it is important that, and we have discussed that in the report also, that such interventions take into account the global impact they have and take input from some of the countries represented in our report. So I think while best practices are being introduced in some of the Western democracies around addressing these new technologies, I think it's important that they now take into account the global perspective. So when our governments copycat these laws, at least they have some perspective in there, because they just copy paste it and then apply in our own jurisdiction, which usually do not really turn out well.
Thank you, Nighat. Back to you, Steve.
I think I'll just have a look, see if we've got any more questions in the Q&A. I think there's there's one question about judicial independence, which I think someone's providing a written answer to that. I don't know if you wanted to try and provide an answer to that, Desi. I think it's to do with judicial independence and the problems of what you do if you've got a captured executive or parliamentary branch of government, which obviously can be a bit of a problem. I don't know if you want to, if you think you can address that or not. You're on mute, so.
Thank you, Stephen. I think I would prefer not to address this because I think it was specifically addressed to Mr. Chan.
Oh, no, of course, no. There wasn't that one of what I was referring to, but no, I think you're right. I think the other question is being responded to in writing as well. I think we've reached the stage where we answered a number of questions. I think we've exhausted most of what's been on the chat and the Q&A, and I did say that we'd get to the part of the session where we'd asked the speakers if they had one takeaway nugget from the session, just a minute or so. So let's do that. Shall we start with Surya? Anything you want our listeners to take away today?
Thank you. I think we'll just make 2 points very briefly. First point is, how can we expand the tent? Because such conversations, to be impactful, we need to really go outside and try to engage those people who do not believe in the values that we are discussing here. And I think there is a significant number of those people in the entire world, but including in Asia Pacific. So I think, how do we expand this tent and have constructive engagements with those people who are in positions of power, whether political power or economic power or technology power? I think that is a very critical component in my view. And the second point that I would like to make is, how can we harness the power of markets to promote human rights and the values of rule of law and judicial independence? So how do we often talk about there's a business case for human rights. In my view, we do not really have a business case for human rights, which is very strong, but how can we make it stronger so that investors and businesses take respect for human rights more seriously? Thank you.
Thanks, Surya. Across to you, Felicity.
Thank you, Stephen. I do have a couple of comments. I think really drawing on the report, it's worth remembering that certainly in relation to sanctions, the consensus amongst civil society activists and lawyers in the dialogue that we had was that the sanctions are a really useful tool for civil society actors to engage with the promotion of human rights, and it has real work effect quite quickly. It represents a measure of accountability, and it puts in place penalties that are specific to a specific situation. And lawyers therefore play that role in the promotion and reform of sanctions, collecting evidence, for example, to identify perpetrators, and ensuring enforcement and compliance. But I think what I'd like to end on is those recommendations to government that we came up with, that targeted sanction programs can allow states to support human rights and promote the rule of law abroad, and create programs that governments can follow. And we give some dot points at paragraph 3.4.1 of the report about particularly in relation to targeted sanctions being fair and appropriate, and having requisite flexibility to take into account the context, if you like, and the range of violations that can occur. and recognizing the role of civil society in providing that sort of mechanism that civil society can share, even across jurisdictions. So this sort of sense of diversity of actors in multiple countries, making use of targeted sanctions and adjusting those for the particular context that they're in. And us as lawyers can sort of provide that support for implementation and enforcement. So I think sanctions and targeted sanctions is a really important conversation to be having. And I'm going to repeat myself at the end that there is this disconnect between corporate criminal law that just should no longer exist. It's precisely where human rights will fail if we don't come out of those silos that we've discussed today. Thank you.
Thank you very much, Nighat.
Yeah, I'll also be speaking specifically around the digital privacy regime and the takeaway, from all the conversations that we have had. We should work holistically towards the explicit goal of improving data protections and digital privacy, and lawyers can play a very, very important role. And while not only drafting the laws, but also while proceeding with the cases in the courts of law, we should avoid silos and jurisdictional restrictions. Also recognize common ground across agencies, countries, laws, and find ways to strengthen those commonalities. We really need to see how we can develop expertise and appreciation for the cultural differences across the Asia-Pacific region, and put the United Nations International Human Rights Framework at the center of drafting and interpreting privacy and data protection frameworks. As corporate actors commit to transparency and accessibility. And lastly, treat the global North and global South equally. One last point I wanted to make, Stephen, that we have so many hopes from the legal fraternity. And why I'm saying this, because we have seen the biggest resistance movement initiated by lawyers in Pakistan and kicked out the dictator back in 2007, 2008. That was the longest resistance movement by the lawyers, set really a huge precedent for all the civil society organizations and civil society in general, that anything can be done if we can work collectively. And lawyers in Pakistan did that. And I think based on that example, I have high hopes that, even in these emerging new technologies and the emerging issues, I think lawyers can take a lead. And that's what exactly we did. We did this through this report.
Thank you so much. Desi?
Sorry. Thank you very much. I just would like to make a couple of remarks with regard to the link between judicial independence, human rights, and social and economic stability. So the International Human Rights Standard, including the Universal Declarations on Human Rights and the ICCPR, have emphasized that judicial independence is one of the essential elements to safeguard human rights. And the interlink here is very evident. If we observe, for instance, the executive opinion survey by the World Economic Forum, for instance, we can see that most of the countries that have lowest rank when it comes to judicial independence are actually those countries with poor human rights and democracy record. For instance, Philippines, Cambodia, Vietnam, Pakistan, Laos, PDR, Brunei Darussalam, China, among others. So when it comes to human rights, we know that judiciary has a substantial responsibility to safeguard human rights protection and realization, so as to ensure that the citizens are treated equally and the other branches of government function effectively. So likewise, judicial independence and human rights fulfillment are prerequisite to peace, as well as social and economic stability. And I like to draw an example from the geostrategic point of view when it comes to social and economic stability. We know with the emergence of Indo-Pacific as a geostrategic construct, it has increased the potential for scope for interaction, engagement, and interdependence among countries in the Asia Pacific. And if you were to look over the past few decades, ASEAN as the status quo in the region has been building ASEAN community, and it has been guided by the same formula, namely a collective commitment to ensure regional peace, stability, and prosperity. So these are strongly linked, as peace is necessary precondition for sustainable economic growth and prosperity. And in the meantime, economic cooperation in turn will produce stability, peace, and prosperity. Not only within ASEAN internally, but increasingly toward the Indo-Pacific or Asia-Pacific, ASEAN has actually adopted a similar formula. It continued to maintain ASEAN's central role in the evolving regional architecture in Southeast Asia. And since Asia-Pacific are amongst the most dynamic in the world, and it has been in the interest of ASEAN member states to help shape the economic and security architecture in the Indo-Pacific. So I think the direction when it comes to the formula is on track here. However, works remain to be done to assure the status quo that respect to human rights and also judicial independence is a prerequisite to attain peace and hence economic stability and also social stability in the region. Thank you.
Thank you so much. Thank you so much. I think the overall message from that seems to be that lawyers can and should be a force for good in all these areas, but we've got to get out of our silos and to do that. And we can do that by reading all four parts of this report and not just the part that relates to what you're interested in. So on that note, we conclude this virtual panel event launching the Edge of Law report, which has been a joint initiative of BHRC and the American Bar Association Rule of Law Initiative. I hope you've found today's discussions engaging and enlightening. I certainly have, and trust that you will enjoy the report and its recommendations. It's a good read if you haven't managed to read it all. It's well worth doing. I'm asked to remind everybody that there's a survey to fill in, which is of importance to all of us, so we make sure that events like this continue to improve. And I'd like to just give our warmest thanks and appreciation to all our speakers who've taken time out of their busy schedules to be with us here today, and of course those who contributed to the report and made the series such a success. And thank you especially for answering questions which have been put to you after your contributions. BHRC would also like to extend special thanks to the Bar Council of England and Wales, the Commonwealth Lawyers Association, and the Business and Human Rights Resource Centre for their support with our publicity for this event since our first session back in November 2021. Again, much appreciation to all of you who've joined us today. We'll be looking forward to seeing you again at future BHRC and ABA ROLI events. And I'll hand you over to Scott for his closing remarks. Thank you all very much.
Thank you, Steve. I'd like to echo my thanks to all the panelists for this enlightening conversation, as well as the research and the drafting of the report. Also like to thank everyone who's joined us here today for this conversation. I hope this is just a waypoint to future conversations. As I was thinking about the closing remarks, I was reminded of an old Shakespeare quote: "The first thing we do is kill all the lawyers." And for those who might think that that's a rather grim approach, it was actually an admonition of the importance of lawyers in that play. And I just think lawyers coming together for these types of conversations is essential. And as the world speeds up, as technology evolves, and people like myself obviously struggling to keep up with even just the basic nomenclature, it's really critical that we continue and keep these dialogues open. And I would also add, while I'm underscoring the importance of lawyers and working at a legal organization, I want to take a note that Professor Deva said in the end of his remarks, and that is about widening the tent. Because if law is just the province of lawyers, none of us, I don't think, will achieve our objectives. I think it's really critical that the larger populations in all our countries have an appreciation for the importance of rule of law and all the various principles that connects to. We have challenges here in the United States, and we fight daily to protect and promote rule of law. It's a journey that is never over, and it's made easier and more effective by conversations like this. So in closing, I just want to thank everyone for their time and attention, and I look forward to the next conversation of this nature. Thank you all.
Thank you, everyone.
Thank you.